Okay. Hey, folks. As I advertised, we are doing a live stream to talk specifically about SEVIS litigation. Adam and I were on the other night, and we had a long session with Andrew Rankin, where we talked sort of about the broad issues generally regarding SEVIS. This time we are focusing on one aspect of it, and there's been obviously a lot of news in the last week and a half, or two. I guess it's about a week since we did that session. There have been several good decisions at various individual cases around the country, and most of you probably have seen it because I posted on LinkedIn about it already. But we're about to participate with our impact partner firms in a class action suit. We also are working on individual cases for people that don't want to be in that particular kind of suit, or for one reason or another are not appropriate for that. And we're working on those cases with our colleagues at Joseph and Hall. We have Zach New from Joseph and Hall here today. Adam Cohen, who is our firm's I don't know what your official title is, but you are basically the czar of university immigration related issues at Siskin Susser, and he represents a lot of universities, and he thinks about student visas all day long. He also happens to be the author of the Academic Immigration Handbook, which is, I think, one of the best books on the subject of university immigration issues. So he's been playing a really critical background role getting us ready for the class litigation as well as the individual lawsuits. So today we are going to talk about the case that we're going to be filing, and I'm going to put up in a second on here where did I put that? Oh, here it is. This is a shortening of a much longer web address, but this is the website for the class action suit. And on that website, if you go there, you will find a frequently asked questions document explaining what we're doing. You will find onboarding documents, which we have produced really quickly to get ready for this using some very cutting edge AI technology. And then you also can the case will be, you'll see on there what the price is to be in the case. It is considerably lower than what an individual lawsuit would cost. So we think that is enough for us to cover our expenses to do this lawsuit, but also low enough that it's probably affordable for a very large number of the students that are being affected. So one of the things that I wanted to address first, we'll be talking about the impact case as well as the individual lawsuits, but some people might ask, well, why, if it's a class action case, do we need people to sign up individually, so many people to sign up individually? And this is a lesson that we learned back in the first Trump administration when we sued on the diversity visa cases, where we had it is very possible that the class will not be certified. It is very possible that for one reason or another, only in the DV case, only our named plaintiffs were able to benefit, even though we were asking for some of the changes we were asking for were going to be changes that would hopefully benefit everybody. So it is possible that only people that are named in the lawsuit would get the benefit of the temporary restraining order, which we'll be talking about on there. And so that's the reason why we're doing a little bit differently than just a class that just names a handful of people for that reason. Josh, Zach, Adam, I don't know if you guys had anything to add as far as that goes, or any other reasons why to explain to people why we're taking that approach.
No, I think just to underline, by being named, that temporary restraining order, any sort of like preliminary relief that we get, it will explicitly apply to you. if you're a free rider to the class action, you're maybe named in the class you would be in the definition. Let's say we have an order preventing ICE from detaining individuals. Well, that very explicitly applies to everybody who is in the lawsuit itself. But if they're still fighting over who would constitute the class, that might not apply to you. And if ICE starts to change its tune and detains people, then not having your name actually in the complaint, that could be a big difference between going to immigration jail or not.
Right. So, but obviously we want to benefit everybody. And that's why we're doing this as a class. So our goal at the end of this is to just stop the behavior on the part of ICE, and hopefully that will a class certification and a good ruling will hopefully lead to that. All right. So let's go back to talking about a lot of people have questions about whether they can be in the class or they can be in the lawsuit. So, and there seems to be, I mean, the common theme for most of the people that we're talking about are they have had something that shows up in a criminal database, and that's what triggered this from happening. We know that there actually are, there's not a lot of them, but there are some people that there's no explanation. They say they have never had any interaction with law enforcement. They have always complied with their student visas. They have no, clues as far as like what the issue is. And those people obviously should be in a case like this. And we have theories. I think that the theories sometimes are name mistakes and things like that are showing that they're matching people based on names, and they're not actually going through and doing sort of like fingerprint matches and things like that. But then there's a group of people who have had run-ins with police, and they had they're in a database, but it was a charge that was dismissed, or it was they were found innocent, or it was the charges were reduced to something that was much more appropriate. They had come with something really serious at the beginning, and then it was just reduced to something that was basically traffic offense or something like that. So that's another group of people who don't have a conviction for anything that would make them removable from the U.S. And then there's a group of people that have pending. They're in the middle of something right now. We were just talking about that group before we went on the air. That group, it's still our position that until a person actually has a conviction, that their SEVIS record should not be revoked. Now, with that said, we were talking as well about what our suit is not doing, which is we are focused on SEVIS and getting that reinstated. And hopefully, if somebody's like F1 status or something was revoked, hopefully the order that we'll get will basically put somebody back in the position that they were in the day before their SEVIS was terminated. But it doesn't solve other problems potentially. So under the Lake and Riley, I never know how to pronounce that act, somebody who's merely been arrested and has not been convicted for a criminal offense could be detained under this new immigration law that was passed by Congress at the beginning of the Trump administration. This case doesn't solve that problem for somebody, even if we're able to resolve the other issue of the SEVIS termination. So keep that in mind. We also, the State Department has been revoking visas for people pretty routinely after a SEVIS termination. And while we would like to turn the clock back on that, the laws are different and not nearly as favorable for people outside the United States, and for consular processing, for consular orders. So that is not something as well that you should have as an expectation if you're in this lawsuit, that if we can solve that, great, as part of this, but that is not something that we have a lot of optimism that our case is going to reverse visa revocation.
Can
So
I add something to that, Greg? Just to kind of present some context for people, because in the conversations I've been having, there's like so much confusion around these different concepts of, the person's visa, the student's visa, right? Their status in the US and their SEVIS record. So what Greg is talking about that is not part of the litigation is the actual visa that you receive from the embassy, or consulate. That is basically your ticket to present yourself to enter the US, right? And it's not supposed to have very much bearing on one's actual status within the US unless they're put into removal proceedings. Okay, so the visa revocation, there's a lot of discretion for that to occur, and that's not really part of the litigation itself. The other two concepts are really very much intertwined, right? So you have your F1 student status, which is your ability to be present in the US. You have an I-94 if you change to F1, or if you enter the US in F1 status. It says duration of status for the expiration. That is tied to your I-20 form, which is part and parcel of the SEVIS database. A student may have multiple I-20s over the course of their studies. That is basically authorizing them and being entered into the SEVIS system for them to transfer institutions, reduce a course load, apply for practical training, things of that sort. So what the government has basically done has, by terminating the SEVIS record, is they've rendered the student out of status. And there's been different opinions about whether being out of status or the termination of a SEVIS record does put a student out of status. But there's some contradictory information on that. But it basically has the effect of putting that student out of status. So this is focused on the status.
I think the sort of the general advice we're giving people right now is, do not expect, if your visa has been revoked, even if we win, we are not recommending travel. We are not recommending that people try and reapply for that, because we think basically, even if we win and we can get you back and we can get everything back in status, and you're eligible to, for employment authorization, eligible for H-1B change of status, all of that, that if you leave the country during the Trump administration, it is basically self-deportation. If you're in that situation, you should sort of look at it that way. It may not be for sure. I guess, Adam, one question is, if they don't revoke the visa, is that still risky? I think it still might be, because the visa could get revoked while you're out of the country and you're not really sure. And the, even though ICE says they are not sharing information and they're not, we know that it's happening, that visas are being revoked. Seems like it happens pretty quickly after the SEVIS revocation happens, but I wouldn't bank on that you're in the clear if some time has gone by. So just be aware of that issue.
One point to add on to that, for folks who haven't received an actual notification that their visa has been revoked, we have been hearing some reports that when they actually log into their old DS-160, they can see that they have a revocation, even though there was no notification sent out. There was no email saying, hey, your visa is gone, don't travel on this anymore. So fully agree. Even if you have not heard anything, it could be revoked after you leave, or it could be revoked and you just don't know about it right now.
Mm-hmm. Yeah, and I'll add to what Zach's saying, because that's a really good point. And I didn't know, Zach, that you could search it, I guess, on that CEAC system, that you could search and find out whether it had been revoked, because I think there's been sort of some issues where, maybe that student doesn't have access to the email address that they used on the DS-160 for like their last F1 visa application. And so maybe that email did go out from the embassy, but they never received it. So yeah, I'll just say, this litigation, I think we'll probably be advising on international travel eventually. This litigation doesn't solve for that, but yes, that is an issue in the future. Whether and to what extent travel will be workable. And I'm sure those are going to be some conversations that we're going to be having in the
Now,
future.
the one group I didn't mention was sort of was the group that actually has convictions, and has a conviction or more than one. And that's a little tricky as well, because it's a question of sort of what you actually were convicted of. Is it something that would make you removable from the U.S.? And I believe that's generally the standard we're using, which is that if if you've done something that would make you removable, or make you out, or take you out of status, regardless of whether these SEVIS terminations were happening. Uh, as I think the example we gave was somebody who was selling alcohol to a minor in a convenience store, but the person was working without authorization. As the second thing, it's not actually the criminal part of it that would make the person not appropriate for the suit, but the employment without authorization part of it, because that would be something that ICE would be entitled to put someone into removal proceedings independent of the criminal conduct. So that, and in our suit, we have screening questions basically that you go through in the app that for the onboarding. But just know that we're not, if you're able to onboard that way, we are still having attorneys doing a second review of everything. And there's a part where you're uploading information, and we may have to tell specific people based on the facts that you're still not going to be able to be a plaintiff in the lawsuit. Hopefully that won't be a lot of you, but that is something that you should be aware of, that if you go through the onboarding process and then hear from us afterwards saying, sorry, we think that you're not going to be able to participate, that's something that could happen. The other reason for that is that in a class certification, we have to show that the plaintiffs that are in the suit, that for a class certification, that they all basically are in a sort of a similar circumstances. And for somebody that is otherwise removable anyway, or has a conviction of a crime that would make them removable, that they are probably not, they're not in the same circumstances, and they could potentially jeopardize the class certification for everybody. So that is something that we had to that we have. It's a little tricky because everybody's situations are different, but so that's why we will have to be doing that review afterwards to make sure that there's nobody in the group that is problematic in that regard. I don't know if you guys have anything you want to add on that.
Well, I'll just
I guess
go ahead, Chad.
My quick thing was just going to be, if you are interested, throw your name in though, because we are going to review it. So, if you're unsure, throw your name in. We'll look at whatever conviction you have.
And if you go through the if when you make the payment, just know, and it says in the engagement letter, that if we after our review make a determination that you're not appropriate for the class, the entire fee will be refunded with pretty much instantaneously after we make that determination. In fact, we may do the refund before we even let you know. So that's keep that in mind. What about people who have been, we've had some interesting questions, and a lot of them we addressed in the FAQ, but people that were trying to pursue other means, like a reinstatement of status. And I know that, Adam, you think that there's some question of whether they're even eligible for reinstatement if there's been a SEVIS termination. But can they participate in the suit as well as pursuing reinstatement of status?
I would say yes is the kind of uncertain answer, but then there's also the guidance we would probably be giving is that once we have the temporary restraining order actually in place, you've got the protection from the temporary restraining order, your SEVIS record's been restored, then at that point to withdraw the reinstatement request, just so that the judge is not confused by having multiple avenues for you to have that SEVIS record reinstated or restored, depending on how you want to phrase it.
Adam,
I'll
what was
add to that.
I mean, what was you? I know you had that you've had some skepticism about whether reinstatement. I mean, you have had a few problems with it. So what are the problems potentially seeking with reinstatement anyway?
Let me just first address this point of the reinstatement still pending as the litigation is ongoing. I would want to just cite that there is a Third Circuit case. Now, my understanding, this would not be filed in the Third Circuit, but there is a Third Circuit case that I think it's called Feng versus INS, and it indicates that my read on it is that it indicates that a SEVIS termination is a final agency action, right? That the reinstatement is not required in terms of exhaustion of remedies, because it is addressing a different thing. It's not addressing spot on necessarily this SEVIS, this particular SEVIS termination issue. So I don't think that a pending reinstatement would necessarily interfere with the court's ability to adjudicate in this situation. But that is one circuit's opinion on the matter. So that's why, I mean, I agree with Zach, just in terms of the withdrawal ultimately of the reinstatement, at least until we get any other type of information about that. I just think that reinstatements generally, the concern, there's a few issues, right? I mean, number one is that they take a while and they cannot be expedited. And it's something that we in the academic community have tried to get USCIS to allow premium processing of reinstatements, because it has such a large impact for students, and students graduate, and and the reinstatement's still pending, right? It's going back to the same agency, right? Or I shouldn't say agency, but the same department that has terminated the SEVIS record, right? You have ICE and you have USCIS that would then adjudicate the reinstatement, but they're all part of Department of Homeland Security. So it's hard to know why there would be any better result under, the reinstatement. And then it also, part of the regulation for reinstatement is that you will pursue are pursuing or intend to pursue a full course of study. And the way I look at it in the regulations, it's hard, if you're on OPT, it's hard to argue that that is a full course of study, that OPT is. I think one could make that argument, but I think that it's a little difficult from the regulations, that OPT might put you past that course of study and make you not eligible from a regulatory perspective. And finally, I'll just say, I mean, we are seeing traction, right, on TROs, not necessarily addressing yet the substance of the litigation, but the TROs and meeting the elements for a TRO to be granted in many district courts across the country. So it seems to just be the more effective strategy at this point.
All right, so why don't we talk a little bit about what a TRO is and what we're seeking, and sort of what the judge has to actually determine in order to issue a TRO. People have been seeing that term on social media, and they've been hearing it from these other cases. But Zach, why don't you give us the quick overview of what a TRO is and why we're asking for it?
Yeah, so a TRO is a temporary restraining order. It's a kind of emergency request for an order from a judge, where you're saying there is something that is imminent and irreparably harmful to me happening. So I need you to make a decision right now as to whether I should be granted certain temporary benefits while the litigation is ongoing. If it's successful, you get this temporary relief for up to 14 days before we then have to convert it into something more long-term, which is called a preliminary injunction. And that preliminary injunction is saying that, okay, for the pendency of this case, here is kind of the status quo that we're going to give you. Your SEVIS records reinstated, you're not going to be detained, those types of things. Really four things that we have to show. The last two combine into one for cases against the government. First is that we are substantially likely to win on the merits of the case, which I think that's a fairly strong argument for us there. The second is that we do have to show that you're likely to suffer irreparable harm absent this emergency order being granted. So that's where we really go into what does the SEVIS termination actually mean. And for the individuals that are in the case, I like to have declarations showing, what's actually happening to me individually. Like SEVIS terminations as a whole say, all these things are going to happen to me. But in my particular situation, I also have these harms that are imminent or actually happening to me right now. And then the last thing is that it's in the public interest for the judge to grant this order on kind of an expedited and an emergency basis, which, hey, having your constitutional rights protected, generally a public interest thing. So not something that judges are typically all that concerned about. What we've been seeing judges really focusing on is that second prong of this, the irreparable harm, because the ICE is making all kinds of really creative arguments, I guess is the nice way to put it, to try to really muddy the waters, I suppose, to make it seem that there may not be as much harm as there actually is by a SEVIS termination. So that's, I guess, in broad terms, what we're doing is we're saying in no uncertain terms, this is the harm that the plaintiffs are experiencing. We're going to win this. And it is in the public interest for us to have this immediate and temporary relief granted for this 14-day period before we have a more in-depth hearing and in-depth briefing on this for a longer-term injunctive relief for the case.
Okay. So we're working together on both individual cases and this class action. Can you talk a little bit about sort of why a person might be wanting to do an individual case versus a participating in the class?
So I think the big benefit for an individual case is you're getting your case tailored to you specifically. You maybe have a different timeline than the class as a whole. You may have maybe it's more particularly complicated facts in your case that we need to address. It may be that you want more hands-on attention, or you want a different place that you're suing in. So there are situations where I think it makes a lot of sense for us to go individually and say, okay, Judge, here's an individual who's been selected in the H-1B lottery. They have a job that says, you're not going to be able to work for us for 6 months. We're not going to hold this position. We're not going to file this H-1B for you. So that person's in a very different spot where they have this potentially long-term and ultimately maybe permanent solution to staying in the United States at jeopardy. Whereas in the class, we're saying kind of as a whole, these are the harms, and we need kind of a more elongated briefing schedule, these harms to be alleviated, this injunctive relief to be granted. So first one, tailored to you individually. Your timeline might be different, your harms might be different, and we really want to focus on that. The second, maybe your risk profile is different, and we want to have that kind of more individual relationship in case something did happen. Maybe you do have some speech related issues that aren't really what this class action is contemplating, and we would want to have that relationship just in case the government changes its tune and we're no longer seeing this general policy of not arresting, detaining students in this situation. We would want to be able to jump into a habeas corpus case for you, or a bond case, very quickly in the event that you were detained by ICE. Or maybe just in general, you are more nervous about the situation and you do want to have that more personal attention. You do want to have that kind of one-on-one relationship where you can email me and I say, hey, here's what's going on right now. Here's what's happening in Colorado. Here's what I'm seeing. If this happens, we can call this guy who I know, and we can file this lawsuit on a pretty expedited basis. So the big benefit to an individual case is you get that individual attention, and your case is tailored to your case. Whereas the bigger benefit to the mass action and the class action is to have the reduced fees and to have kind of this pooling of resources to have the ultimate remedy fixing this for everybody. So I think both make sense. I think that some make sense for some people and some make sense for others. And if you're interested in an individual case because you do want that individual attention, I don't think that's a wrong decision by any means. And at the same time, I don't think it's wrong if you're saying I'd like to join this class and get this moving kind of as a group, so I can have this this snowballing effect of 500 people hitting ICE over the same issue and getting this order protecting all of us. So both have their pros and cons. Really, it's the individuality of the two situations that differentiate them.
Let's talk about. Oh, sorry.
I just had one question for Zach. I guess I was wondering also, since we were talking about some of these other, sort of criminal issues or things of that sort that might make the person not right for the class action. Is that a situation where you think it might be good for that person to at least, inquire about their own individual lawsuit?
It could be, yeah. So there's situations where somebody maybe is not good for the class action because they may jeopardize the class definition. We say, here's a particular group of people we're suing over for this class, and you're just not quite a great fit for being in that definition. But you may still just have a great individual case. There may be complications to it, and we may have to address those. But your ability to sue over your SEVIS termination, it doesn't go away just because we don't think you're a great class representative. So yeah, that's absolutely a situation where having a more in-depth discussion with an attorney, perhaps about what the risk profile is for you, what your convictions, if you've got them, or your status violations, if any of those are in play, what those mean for your case. Yeah, that makes a lot of sense to me.
Okay, let's talk about timing. So there's we're moving this obviously very quickly because people really need relief as quickly as possible. I think what have we said is our deadline for onboarding? It's like early
noon Eastern on Monday.
Okay, so that's when we will close off adding people to our onboarding. Gives people at least a couple days and then the weekend for that to happen. What is the goal as far as when we're filing?
As I understand, we want to get the initial filing for this in on Tuesday evening. So we'll close the onboarding Monday afternoon, and then the following evening have that first big filing in front of the court.
Okay, and then what happens after that?
So then after that, we're going to get that temporary restraining order motion really going. So we'll have to put together the specific harms for individuals and for the class as a whole. We'll have to put together why we're likely to be successful, and we'll throw that in front of the judge to get that temporary relief. And then simultaneously, we'll be briefing what's called class certification, which is, why is this case something that should be representative of everybody in this particular situation, that they have this common set of facts and law. Yeah. So we've got these kind of two simultaneous filings that we're going to be pushing forward, that temporary relief for folks, and then why should this represent everybody in this particular situation.
And the temporary relief, I mean, a lot of that's going to be reliant on our declarations that we have from folks. And can you tell people like what the declaration is, and also how we've made it a lot easier for people to do that?
Yeah, so I guess the how, it's very much automated. I mean, Rick's firm, this is Susskind firm as a whole, with Visa Law, has this terrific AI program that we're able to use to automate a lot of what we're doing for this litigation. So when you're putting in your facts, you're putting in your particular circumstances, it'll help generate this declaration that we'll be using for the temporary restraining order. For the facts themselves of what we're looking for, it's why am I being harmed? Why am I being harmed, and what's the imminency of this? What's the timeline on this? If I'm saying I would love to start a degree program in September, and right now I'm not able to transfer my degree program, well, that's not necessarily imminent. So that temporary restraining order, that emergency, I need this right now, maybe doesn't fit as much as it would in the case of somebody who's, I graduate in a month and I am unable to attend classes according to my school right now. So we want to see your particular harms. And then, I mean, we also have the harms that come from a SEVIS termination as a whole. So it's not as if you have to have this very, very particular harm to you for us to file for these TROs. People are doing this under pseudonyms where they don't identify any personal information at all, and they're still having TROs granted. But in general, we're showing this is the harms that I'm suffering, and that is being incredibly automated, pretty simple and quick process as you're going through the onboarding process.
Okay. So if we get this TRO, is the case over, or what happens after that?
Right. So the TRO is really a very, very preliminary step and a very temporary step, a temporary restraining order that can only last 14 days at the most. So it does give you that little benefit at the very beginning, but we then have to convert that into that longer term benefit, that preliminary injunction, which has the same standards, has the same things that we're going to be arguing. It's just going to have a lot more legal argument behind it, a lot more evidence behind it, and the government's going to have a bigger chance to respond. So it's certainly not the end of the case if we get a TRO. The TRO is something that we certainly want to make sure that people have their benefits as soon as possible, but it is not the end point, because after that we do want the preliminary injunction to take you all the way over the finish line of the case, but then we have to have that class certification for it to really help everybody as a whole. And once we have both of those in place, then we really move forward with the litigation in earnest, as if this is just a more normal case. We go into motions practice, we call it, where the governments are filing motions, we're filing motions, we're having reports with the judges, and scheduling conferences and things like that. Then this ends with what you could kind of consider to be a trial. It's not an actual trial. We wouldn't have a jury. It's not going to be witnesses, most likely. It's mostly done on paper. We file what's called summary judgment, saying who wins. Here's the facts. Here's the law. Who's right? Did the government break the law, or did they not? So that's the very, very end point. But to get there, we want to have that preliminary protection for everybody, so that their status is restored and that they're protected from detention during the pendency of the case. And we also want to make sure we have that class certification granted so that it can benefit everybody who's been impacted.
And the class certification, do we have any idea sort of the timing on how long that's going to take?
I'm not sure we have a great filing deadline there. I would say that it would be within the week for us to have that all the way put together.
How long do you think, though, the judge would take to? I mean, to make? Well, they have to actually certify the class. That's the first thing. So we make a motion that we want it to be a class. Is there sort of a deadline on when that decision comes, or judges have as much time? I guess they could take as much time as they want. That's how judges are on there. But I have a feeling if we're successful with the TRO or successful with the preliminary injunction, we've already had 2 successes with that judge. There's probably a decent chance we're going to get that class certification probably fairly soon after that, if we're already on that path with the judge. And it very well may be. I think probably, and class actions can be settled just like any other kind of case. So that's something as well. We don't necessarily have to. It doesn't have to go through to the to a trial in order for us to be able to get what we want, which is to stop is basically to get everybody reinstated and to stop further behavior like this. I think do we have any more subjects we want to talk about with relating to either the individual or the class case? Otherwise, we can answer. I think we just have one question here, and we can end early. And this is going to be recorded, so if anybody's watching this that needs to tell friends about it or anything like that, it will be here, wherever you're seeing it, and it'll be remaining here. So
I think I just have one point, just in terms of how the questionnaires generate. There's sort of, I guess, 2 stages in terms of the questionnaires that you'll see when you're onboarding. One of them is asking, the first one is just asking some very basic questions, but it's trying to ascertain whether there's any significant type of convictions, like those related to drugs, crimes of violence, and things of that sort. And if that is an issue, it stops the moving on to the second questionnaire, and that would probably be something where then you would want to reach out, maybe even have individual consultations, with our office or with Joseph and Hall. Maybe look into, especially if you're looking into maybe individual litigation options, that would be helpful as well. If it moves onward from there, right, you don't have any of these disqualifying convictions, then you're going to be providing more information, about, we've seen a variety of things like traffic tickets and things of that sort, which really are very, very minor, and other dismissed charges. And so you're providing more detail about that, but also what Zach was saying about like the hardships and, what your long-term plans are in the U.S. And things that you were working on when, this whole situation occurred. And that's going to help generate the declaration. But it will also give us more information, especially as it relates to the criminal charges, to still continue, as we were saying, assessing eligibility for this class action litigation. So I just wanted to throw that out there in case anyone had any confusion in terms of as they were going through that onboarding process.
Okay. So we did have one question. I'll post it here. Sorry to block you, Zach. I don't know how maybe Adam, you can figure out how to reconfigure the screen so everybody can be seen. But somebody had asked a question regarding STEM OPT. Well, there's two parts here. There's STEM OPT, and then the person's between jobs, which I'm not sure if that means that they are in that unemployment grace period that you have on STEM OPT. You can only be unemployed, but I'm not sure if they mean between jobs, like they're changing positions, which is, it's possible. But STEM OPT, those folks are in SEVIS and they're affected by this. Zach, any reason why they wouldn't be eligible to be in the case because you're in STEM OPT versus actual still active studies? I don't see a problem with that. The harms might be a little bit different. Like it might make it difficult. And we kind of explained before, I think, Zach, you were talking about the H-1B cap gap situation as an example. There or somebody who could be in regular OPT or STEM OPT. But in any case, that person who's having their SEVIS record revoked that's in that status is at a lot of risk as well. We've heard problems with E-Verify showing that somebody is no longer authorized to work, even though their EAD card seems to be, they haven't gotten a notice of revocation. Something is showing up in the system. They have, the inability to do other kinds of changes and extensions, et cetera, when you don't have a SEVIS record. So anyway, and actually, and we had a follow-up comment on that. It said they were interviewing, contract ended. All right. So, Adam, you look like you had thoughts as well about this question.
Yeah, it's hard to know whether this person is somebody who's kind of caught in the ambit of this situation anyway, but, a SEVIS record termination is a SEVIS record termination. So, the litigation is for those who are currently enrolled, or they're in post-completion OPT, or they're in STEM OPT. And I would say to the question about just being between jobs, it's okay to have some unemployment time, right? You can have, with a combined OPT and STEM OPT, you can have up to 150 days of unemployment. So just be aware of that. I think what's so frustrating about this SEVIS record termination issue, right, is that you're supposed to be able to, report your unemployment time through SEVIS. Report your employment time through SEVIS so that you don't have this unemployment counter going. You're reporting it so that it is understood to the government that you have not accrued, the maximum or past the maximum unemployment time that then, puts you out of status. And that reporting functionality is not available when you have a terminated record with an OPT student portal, closing soon thereafter. And the DSOs have no ability to go in either. So that is frustrating, but you would have the unemployment time typically. I'm not sure. I guess I'm seeing some more comments here, Greg.
No, this was from the same person. So I think it's what you were saying basically, is that
it was valid, just switching job.
there's no, he apparently had been told something that wasn't, his situation wasn't going to be, an immigration lawyer told him that he wasn't going to be eligible, I guess, to litigate, or what the issue was. But so I think that person may need to reach out to us separately, but it looks like that we're making it clear that people in STEM, OPT and STEM OPT situations are eligible for this suit, and the SEVIS, the harm that they're suffering from the SEVIS termination, is in fact something we're trying to remedy with our lawsuit. Okay, I don't think we have any other questions. I'm going to put one last time back the link for if you want to learn more about the suit, and I'll have also I'll post about it on my channel. Zach and Adam, I'm sure, will do the same. We're going to end because we actually have to get to work and work on this case. But hopefully we gave you some good information today. You can pick up more information on the website in the frequently asked questions document. We will be no doubt adding questions to the frequently asked questions document as we get the questions from people. And then, like I said, you have an idea now of sort of what our timing is. So if you are interested in this suit, keep in mind our Monday deadline to have the onboarding. The good news is we've made it so it really is fast and efficient for you to give us the information that we need in order to onboard you into the case, using some very cutting edge AI technology to make that happen. So anyway, thank you for watching today, and we will be updating as we make progress in this case. And thank you, Zach. Thank you, Adam.
Thank you, Greg. Thanks, Zach.